Hi, hello everyone. Welcome back to my channel. We are back with the glossary of legal terms. The first phrase today is intra-vires. Intra-vires describes acts performed within the legal authority or statutory power of an individual or entity. Public officials or corporations must act within vires. Acts beyond that authority are considered ultra vires and legally invalid. This doctrine ensures agencies and companies do not exceed the delegated powers. Courts can strike down ultra vires acts to protect individuals and the rule of law. Intra-vires compliance promotes accountability and prevents unlawful overreach. The next phrase is in loco parentis. In loco parentis means in place of a parent, referring to legal responsibility by an individual or institution over a minor in absence of natural guardians. Examples include teachers or boarding schools exercising care akin to parental duties. The doctrine imposes duties of supervision, safety, and welfare corresponding to parental standards. Breaches may result in liability for negligence or failure to care. It highlights how legal responsibility attaches not only to parents but also to guardians acting in their capacity. The next phrase is intestacy laws. Intestacy laws are the legal rules that determine how a deceased person's estate is distributed when they die without leaving a valid will. These laws vary by jurisdiction, but they generally prioritize close relatives, starting with the spouse and children, then extending to parents, siblings, and a more distant kin. The purpose is to provide a default plan that reflects presumed family ties and dependencies. If no eligible relatives are found, the state usually estates to this date. Intestacy laws do not account for personal wishes, so assets may be distributed in ways the deceased might not have intended. The next term is injunction. An injunction is a judicial order compelling someone to do or refrain from doing a particular act. It can be temporary, that is pending a hearing, example interim or interlocutory, or permanent as a final remedy. Courts grant injunctive relief when monetary damages are inadequate or irreparable harm is likely. Non-compliance can expose the party to contempt proceedings. Injunctions feature prominently in disputes over property rights, intellectual property, employment, and environmental matters. The next phrase is in personam. In personam jurisdiction refers to a court's authority over a specific individual or entity based on proper service of process. Such a jurisdiction enables courts to bind the person everywhere with respect to enforceable judgments. It contrasts with a in rem jurisdiction, which concerns disputes over property rights. Courts assess residence, contact, or presence to establish in personam authority. Valid in personam jurisdiction ensures fairness and a legal legitimacy of court rulings. The next phrase is in rem. In rem jurisdiction addresses the status of property or rights against all the world rather than specific individuals. Examples include maritime salvage claims, forfeiture proceedings, and title actions. The court's power attaches to the physical object or property located within its territory. Judgments in rem affect all potential claimants regarding the rights or status of that property. It resolves specialized functions like resolving ownership or granting relief tied directly to assets. The next phrase is in propria persona, also called a prose. In propria persona, also called a prose, means representing oneself in court without an attorney. The litigant acts independently, filing documents, making appearances, and presenting arguments. Courts often provide limited procedural guidance, but they cannot advocate for the party. Self-representation can arise by choice or necessity, especially for indigent individuals. It requires the litigant to comply with the legal rules and the deadlines with no professional aid. The next phrase is interim clause. An interim clause or no contest clause is a will imposes penalties on an heir who contests the will, typically forfeiture of bequest. Its purpose is to discourage unnecessary disputes and maintain peace within families. Courts generally enforce these clauses when their challenge is frivolous or lacks probable merit. However, valid challenges, example, proving undue influence or lack of capacity, may be exempted. These clauses balance deterrence with access to justice when genuine issues arise. The next phrase is inevitable discovery. The inevitable discovery doctrine allows evidence obtained improperly, for example via unlawful search, to be admitted if the prosecution can show it would have been lawfully discovered anyway. It balances constitutional protections against unreasonable searches with practical investigative needs. Courts demand a proof that lawful methods would have led to the same evidence absent misconduct. This exception prevents exclusion of reliable and probative evidence when error did not prejudice defendants' rights. It is applied cautiously to avoid weakening constitutional safeguards. The next phrase is irresistible impulse defense. The irresistible impulse defense asserts that mental disease or defect caused an uncontrollable impulse leading to the crime, even if the defendant knew the act was wrong. It goes beyond a mere lack of intent to focus on inability to restrain action. This defense complements or substitutes for insanity tests in many jurisdictions. The standard requires expert mental health testimony and a legal evaluation. Courts weigh moral culpability differently when impulse overwhelms volitional control. The next phrase is insolvency or insolvent. Insolvency occurs when a person or business cannot meet debts as they fall due or liabilities exceeds assets. It often triggers legal proceedings such as bankruptcy, liquidation, or corporate restructuring. Insolvent status affects creditor rights, priority of claims, and available remedies. Legal systems classify insolvency to determine whether rehabilitation, asset distribution, or creditor protection is appropriate. It plays a central role in a commercial law, consumer protection, and a creditor-debtor relations.